Please be seated. I'm having just a little bit of iPad trouble today, and it's blanking out the name of my cases for this afternoon. Hold on. Old school paper. Thank you. We are here this afternoon for the argument of two cases and the submission of a third. The case of Cody Smith versus State of Iowa is hereby submitted without oral argument. And we will begin our first oral argument today, Greenbelt versus Stephanie Van Mill and others. Mr. Kramer, looks like you're ready to go.
May it please the court, counsel. My name is Jonathan Kramer, and I represent Greenbelt Bank and Trust in this matter. I want to start by saying that after the briefing was completed in this case, I did learn that Mashon Van Mill was criminally charged by the United States. As far as I know, that would not have any effect on anything that we're talking about, but I felt out of candor to the tribunal that I wanted to at least make sure that you were aware in case that that would have something. I understand there's been a plea agreement, but otherwise the case is still pending. Today, Greenbelt is asking for a reversal of one portion of the district court's opinion, and that was the portion that found that that an exemption applied under Iowa Code Chapter 642.21 in this matter. There are lots of different directions that our argument goes to get to the same path, but all roads lead to that same one, which is that finding was inappropriate and should be reversed. One path, kind of in the direction or the priority that it seems like this court usually goes, the first path you could take is the path under the procedural issue under 642.15. In this case, that's our standing issue. Definitely, Mashon Van Mill is the judgment debtor involved. He was physically present at the hearing. He was served with notice of the hearing relating to the garnishment dispute. Did not file anything, did not raise any exemptions, took no action of any kind in order to attempt to protect his rights, which 642.15 would require. And so that would be something where this court could say, because that procedural issue is not raised correctly, that Unverferth was not in a position to have standing to be able to raise that with another party there, and therefore the determination could be gone.
The standing argument, because you file a sort of a, I don't know what it's technically called, petition for garnishment, whatever it is, and then Hilltop, Unverferth, not Hilltop, Unverferth files an answer, and you're saying in the answer they're not allowed to raise the exemption. That seems to me kind of odd, because normally you talk about standing as what arguments can a plaintiff raise or petitioner raise. I mean, they are allowed to file an answer, and this is one of the defenses, so why can't they just answer? Yeah, and definitely everything in collections law, I think, is a little odd. It has been treated odd for forever. As a practitioner in the area, I can say, yes, when you look at the garnishment statute, there are aspects of the garnishment statute that are a little cleaner, actually, comparatively, in my area of practice. So when you look at 642, it's laid out pretty cleanly to say, first there's the garnishment interrogatory response. There was a response, it was then there was an amended response. That doesn't generate a court action where there's actually a trial or whatever. So the plaintiff, the judgment creditor, has to start that action against the garnishee. We did that. 640, it's 12 through 15, but particularly 642, 12, 13, 14 goes down the process, and it says what we're doing is you're determining whether or not the debt of what the garnishee claimed was owed to the judgment debtor, if you disagree with their calculation of the debt that they owe your debtor, you can dispute that. And under 642, I think it's 13, it says that if at that hearing, the court finds and determines what the amount of the debt is between the garnishee and the judgment debtor. That is the amount of the judgment against the garnishee. It says for the full amount of the debt. It doesn't talk anything about any other defenses. It is a determination of the amount of the debt. And then it goes into 642.15 that says, but if somebody wants to claim for any reason that any portion of that debt is not exempt or shouldn't be considered, the person that is supposed to do that is the judgment debtor, and they do that by filing a pleading, and they are joined. They have to have notice under 642.14 and 14A, and I think there's another statute in there too that says they have to have notice. Here, all of the notice provisions were there, but they did not take a position on that. And so the court has to say, well, when the legislature said only the garnish or the judgment debtor has the right to file that pleading and raise that issue, are we just going to ignore that? And that's, again, that's when I look at this statute, it seems very clear that that is the issue.
What is the timing of the notice? So garnishment, then notice to the judgment debtor, simultaneous, before? Could we wind up with a situation where garnishment is served and then paid before notice is actually served?
No, there's several different notices, and so no, I don't think so. So the first one is if the garnishee were to answer the sheriff's interrogatories in the affirmative, then at that point the sheriff has to let me know as the judgment creditor. We have to file something with the court to let people know, and a notice has to go out to the judgment debtor at that moment, because that was the due process issue that the federal court had some issues with, within the last 10 years or so, which is why we amended the garnishment statute. This issue is different than that. This is saying after the garnishment interrogatories are received, if the judgment creditor disputes those, then we have to file a pleading that actually adds the garnishee to the case. That has to then also be served on the judgment debtor, and it was. So there's two separate notices there where the standard issue is normally that it is an employer circumstance. So in, 99% of the cases or something, that what's happening is that the HR person at some company that employs somebody gets a notice that says you're supposed to do this, and then they fill it out the best they can, they send it to the sheriff, and they immediately start withholding some amount of funds. This is just a very odd circumstance that it's not like that at all. Here, the people that owed the funds didn't withhold anything. They actually initially said, yes, we owe them $100,000 a year. Then they said, no, we don't owe them anything. And then they fought and said, no, we don't even have this relationship. There's this other, fictional company that now exists and whatever. So this, on a factual basis, is so different than what normally would happen. But here, in terms of the notice issue, there's a whole separate notice. That petition by the judgment creditor against the garnishee has to be served on the person. And the concept in the garnishment area is that this is a three-party deal, right? You're owed money. We need to have the court determine how much money you're owed by this third party. And of course, you're a necessary party to that. You can come and if I say, no, it should be.
A second. I didn't do any collection work, but I certainly, as a trial judge, saw a lot of cases, so you know more about it than me. I'm looking at it very simplistically. For not an employee, would you agree with me? He was not an employee.
There's no dispute that he was not an employee.
Full of the word employees, the exemption from net earnings. It's just full of the word employees and an employer. So help me understand, why do we squeeze in somebody who's not an employee and treat him the same?
Believe you should at all. I think that was an error that was made in the Marion County or Health Systems Cooks case about Willie Cooks. That was the Court of Appeals case that said, well, independent contractors have to eat just like employees have to eat, so we're just going to say that the legislature intended to cover everybody. I don't think there's any basis for that. Quite the opposite. Independent contractors include everything from somebody doing odd jobs and barely scraping by that can't get employment because of any number of issues, from drug addiction to disability to whatever it might be, all the way to somebody that has 400 pieces of equipment and they are doing dirt work as a construction contractor in 15 states. There is no line because they're all under the concept of independent contractor.
You kind of with respect to who's being paid the money in terms of honoring the entities that are at issue, right? So if the judgment debtor is Van Mill personally, right, not his company, but the payment, if the payment is going from the garnishee and not to him personally, but to a legal entity, does that matter?
So here, again, the facts are odd. Van Mill Farms is a judgment debtor. Van Mill Farms was the contracting entity all the way until March of 22. Van Mill and Unverferth agreed that they was going to change that, so it went out from the judgment debtor and created it didn't create anything, just changed the name specifically in order to avoid this, right? So again, the facts here are horrific. And they're very different. But the reality is, yeah, if this was an actual legal entity, right, if Hilltop Industries existed as a legal entity, my recourse would be to sue Hilltop Industries under 684 as a fraudulent transfer or as a successor liability issue. I would seek an injunction, ask for a receivership. I do all that stuff because this guy's doing this, right? But that's not what happened here.
My concern is that maybe the action might be against the judgment debtor's entity versus this particular garnishee, but you're just saying they changed the name without changing the legal entity. As far as
Nobody knows exactly what Mashon Van Mill was thinking in his head. The testimony and the record at trial was there is no entity and has never been an entity called Hilltop Industries, and that everybody involved knew that they didn't have a social security number, there was no EIN, but more importantly, there was no filings. Nobody bothered to do any of that due diligence. So when we garnished and they said no, they decided to fight. And when I said, where is the proof that this entity even exists? Again, of course I have to care about that, right? That would be something I talked about in the very first day when you get the interrogatory answers back. But there is no Hilltop Industries. When you look at the actual invoices, you can see he didn't change the logo. He didn't change the format of the invoices. Hilltop Industries continued from the same invoice numbers from Van Mill Farms. Again, Van Mill Farms is a judgment debtor. It is not just an entity. It is a debtor entity. This is all income and stuff that was part of the entity that we loaned money to that he tried to remove fraudulently. But in this case, the only issue for this court is to say, well, is this exemption should apply? We're saying there's lots of reasons, but absolutely not. It is critically unfair for an exemption to apply when he didn't claim it, and he's not entitled to it because he's an independent contractor, and the stuff that it was actually for aren't personal services, right? Selling pallets, they're goods. They can't be services, they're goods. It's impossible for this to be correct. And I think the issue is we've got the Cook's case that says independent contractors sometimes can be. In the employment context generally, this court is very familiar with the concept that there are sometimes disputes over whether somebody's truly an employee or truly an independent contractor. That is not the case here. 100% independent contractor, right? So the issue is, well, in the legislature's wisdom, when they said employer, did they mean employer or did they mean everybody and we just ignore that? And if you say that it means everybody, then how do I tell somebody what the use of the word employer under the duties under .21 are, right? Because an employer has to know information about the person. They have to report what the expected earnings are going to be. Let's say it's a roofer. How does the roofing customer have any idea what this guy's expected earnings are going to be? Right? This case, it's somebody that is a big, powerful entity that is the garnishee. But it didn't have to be. In the Cook's case, it was a bank that paid a guy $25 a week to come for 2 hours on a Monday. You know what I mean? As the person who is responding to the garnishment, I need to know what my duty is. And you shouldn't have a duty to go and figure all that stuff out if it's a true independent contractor relationship. If it's not a true independent contractor relationship, if it's really an employee but it looks independent contractor, you can do the same analysis that we regularly do with the economic realities doctrine that they do in, for Fair Labor Standards Act and all of that stuff. You get to look deeper. That is not the case here. 100% this is independent contractor, and none of these are personal services, even if he was an employee. That's not what these are for. So we just think it's wrongful.
Resolve this case without necessarily overruling Cooks. On the facts that, I get your point, sometimes independent contractors are people who are working by themselves and they're kind of contract labor really in the nature of employees. But that's not this case. This is a true independent contractor company, maybe with other employees potentially providing goods, and that's not an employee under any definition. Correct. Okay.
Thank you. You may be seated.
Thank you. May it please the court, Mr. Kramer. I want to start out, I think it's important to understand the procedural history here because I think Mr. Kramer made some statements that I don't think are quite accurate. In the trial court, originally when Greenbelt Bank sued all these defendants that are listed in the caption, Van Mill Farms, Stephanie Van Mill, and some others, the end result of that was a personal judgment in the amount of $2,600,000 against Mashon Van Mill. There was no judgment entered against Van Mill Farms other than an in rem judgment to get back some real estate. There was no personal judgment entered against Stephanie Van Mill. There was a judgment against her for $175,000 that was awarded, but the order says that it's not entered. So I presume that from reading the order of the court originally, when this thing started, was that they owned some property together, and the $175,000 that was awarded was also in the nature of an in rem judgment. So the only personal judgment that arose out of the lawsuit originally by Greenbelt Bank resulted in an in personam judgment against Mashon Van Mill for $2,600,000.
So I have this fact right. Was the garnishment in the name of, did it name both Mashon Van Mill and Van Mill Farms LLC, both of them? It didn't, it just named him?
Garnish monies owed to Mashon Van Mill. That was it. So the notice of garnishment was served on Unverferth, and they responded, as Mr. Kramer indicated originally, saying, yeah, we paid him, we expect to maybe pay him $100,000 a year. But then a week later, upon examining that, they amended those answers and said, no, we aren't paying Mashon Van Mill anything. We don't show any payments going to Mashon Van Mill. So obviously, there was no incentive on the part of anybody, Mashon Van Mill included, to file any claim of exemption because there was no withholding being taken from any of the money that Unverferth was paying to Top Hill Industries. Now, the testimony, so it's our position that Unverferth responded accurately to the interrogatories, and that the record does not show any money ever being paid to Mashon Van Mill. They had in the past, Unverferth had paid Van Mill Farms for work done, which they were invoiced for and paid, and that was to Van Mill LLC. And then, and those services consisted largely of snow removal, lawn mowing, bagging grass, building pallets that they would provide to Unverferth. And I think it was about the spring of 2022 that Unverferth was notified that you're going to be billed by Top Hill Industries, and go ahead and just pay Top Hill Industries. At the trial, there was testimony that Stephanie Van Mill obtained an employer ID number different from the Van Mill Farms, and then directed to Unverferth to pay Top Hill Industries and issue any, and keep their records on the employer ID number pursuant to that number. So Mashon Van Mill's Social Security number never has appeared in Unverferth's records. And then the evidence also indicated that during the garnishment period, Unverferth paid Top Hill about $121,000. And the court, upon hearing that evidence, determined that there was an independent contractor relationship with Van Mill.
On that point, do you think that the Marion Health case should be overruled?
No. No, I mean, no.
That case, it says that employee in 642.21 means independent contractor also. And I guess as I understand your argument, independent contractor would be separate. And so you guys would simply pay the independent contractor, and whatever the judgment creditor is chasing, they would go after that contractor and not your client.
Yes, I mean, that was our position at the trial, and we have not cross-appealed on the issue that the judge made a mistake in limiting the judgment to 10%. So 12,000.
I get it's your maybe fallback argument that 642.21 applies to limit that amount, but I guess your first position, as I read it, was you shouldn't have had to pay anything.
That's correct. Now, the bank has raised
On this, you've waived that position at this point, correct?
appeal. So it's our position that we either pay the 12,000 and no more, and that's what our position is today.
On the question of, I mean, the basic question, your position is that this exemption, 642.21 exemption, should apply even to independent contractors, right? And the only authority cited for that is this Court of Appeals Marion case, correct?
Case out of the bankruptcy court, Southern District of Iowa, the Sexton case.
Court of Appeals? Yeah. So, and the Court of Appeals decision doesn't talk about the statutory text in terms of the 5 or 6 times that the chief was referencing that it talks about employee, right? Yeah. I have trouble with that. Can you help me?
And, but I think the Court of Appeals determined that the legislature wanted to protect independent contractors that were sole proprietors. It doesn't say that, but that's kind of implicit in the decision that, you know, if you're providing personal services to someone that's garnished, that you should have the same protection as an employee.
Agree with me that the legislature regularly uses the terms employee and independent contractor in all kinds of statutes. Yeah, so they know the distinction and could have easily said here, you know, by employee, we mean also independent contractors. Yeah.
And then there's also this incorporation of federal law, and then federal law talks about disposables, earnings of an individual for any work week. Well, that sounds like, even that phrase sounds like someone who's an employee who gets a regular amount of pay every work week as opposed to an independent contractor like Mr. Van Mill, who went up and down. Now, I mean, we're not bound by the Court of Appeals decision. It's been around a while, but we're not bound by it. You would agree with that? Yeah, right.
But the bank raises really three issues as to why this should not stand. One is the issue of standing. And I do want to comment a bit about that. The way the garnishment statute works is that once the employer is served with a notice of garnishment, that they respond as to whether there's any money owed to the judgment debtor. And then on the back of the garnishment form, there are instructions to the garnishee that if there is money owed, to what to withhold. And it says if you pay over $50,000, you withhold 10%. That's the most that can be withheld under the as specified in the garnishment notice. So when that happened here, and Unverferth responded by saying, we don't owe this guy anything. I think that was accurate. They didn't, and I think they have then standing in an action like this, a collateral action, to argue that.
I guess I'm not so, the standing argument doesn't move me so much because it seems to me that, Unverferth could be in trouble, in the run-of-the-mill situation if you don't assert, if you have a regular employee and you don't assert the exception, then later on the employee could come around and say, you violated the law by letting them take that much of my paycheck.
Correct.
And then you're paying two people.
Yeah. So, as I was saying, the bank has raised three arguments, one being the standing argument. The second is that Marion Health Center was decided wrongly. And thirdly, that there was insufficient evidence in the record to show that the monies paid by Unverferth were for personal services, and that they weren't, that they were. That there was money paid for constructing pallets, and that the record doesn't show that Mashon Van Mill actually did any of the work. And so that's their assertion on that. However, let's just for a minute speculate that if the court buys into that argument and looks at the record, which I'm sure you will, and determines, the record, there's not substantial evidence in the record to show that Mr. Van Mill performed those services. There is, and that the payments were actually made for merchandise in the form of pallets and other things. Let's say you go down that road and you read the record and see also that Stephanie Van Mill was the one that initiated the obtaining of the ID number for Top Hill Industries. I think that bears poorly on the bank's case. That just enforces the fact that that Unverferth never did pay Van Mill. They didn't owe him any money, never did. They may have owed other entities, but there's that I think you have to look at that record to see the nature of the services. If you can determine that I think under the record, if you determine substantial evidence exists that it was for personal services, then I think you need to then probably deal with the Marion Health Center case. But if you determine that the record's insufficient, I think we're stuck with the ruling of the Court of Appeals as far as the amount that has been determined.
kind of speak in favor of a bright line rule. Figure out if it's an employee or an independent contractor, because it seems to me if the test is an independent contractor who's providing personal services is subject to the limit for the personal services, that's going to create lots of litigation in these kind of run-of-the-mill collection cases, wouldn't it?
This is a complicated issue. Once the door is open, you can construct all kinds of what-ifs. But I'm saying, if you find, in looking at the record, and say the bank is correct and you don't think there's sufficient evidence that Van Mill provided personal services, then I think you probably don't have to even examine the standing issue or the Marion Health Center case, because then I think you find that there's no evidence that Mashon Van Mill got any money, and that therefore the answers to the garnishment questions were entirely correct. So there's many different roads that you can go down. I don't know where you want to go, but I think that's problematical. Had all these other things I was going to say, and now I've run out of time.
You bet. Mr. Kramer.
May it please the court. I apologize. I believe that we have a judgment against Van Mill Farms and that is part of the original judgment. This is the first I've heard that somebody read our original judgment to not include that. I don't know that it matters, but.
I'm looking at the notice of garnishment, and there's kind of a few in here. And there's maybe one that says Van Mill, comma, Mashon Michael, so just him. And then I think there's another one that says Van Mill, Mashon Michael et al. So, but it's not clear to me that the garnishment ever explicitly listed payment that would have been owed to Van Mill Farms LLC. And if that's true, then and if we read independent contractor is not part of 642.21, then isn't it right that that there wouldn't have been any garnishment that you would have taken from the individual here?
No. Yeah, no, that would not be right. Under 489, any LLC has to do business in its own name. You can't have a unfiled fictitious name of an LLC. So when Mr. Mashon Van Mill, in his wisdom, decided to change the name to Hilltop Industries, then Van Mill Farms is no longer anything to do with it, right? Because now he has generated a fictional name that can only be assigned to a human. So there is no such thing as a sole proprietorship of an entity. You can't have that under business law. So the concept that what he did by giving a name that was never an entity, knowingly, creating that, was kind of something that would have hurt him if the court was focused exclusively on this Van Mill Farms Act. However,
Mr. Cady's client's problem, though, or is that Mashon's problem?
no, I think it's, and again, I'm not on the Supreme Court, but I think that my rule would be you have to know who you're doing business with. I think the concept of having the idea that you have an independent contractor and your ability, your concept is so loose that, oh yeah, you can just say I'm doing business with whoever you want to say is doing work for me. To me, that feels a little loose from a legal perspective. I think it's okay to say that the minimum standard for everybody is that if you're doing business with somebody, you need to know who that is. And I think that's consistent with all of the Internal Revenue Service regulations. And it's not hard. You get a W-9 form, period. The W-9 form becomes a certification. It's right there under penalty of perjury that this is the social number, this is the entity that's involved, this is the EIN, whatever. But it has to have an actual entity. Here,
somebody said, hey, I've got this entity, it doesn't have an LLC on it, it doesn't have an Inc. on it, it's not difficult for somebody to say, hey, I need something, give me a copy of your articles, or give me a copy of your certificate, or anything, literally anything. Here, they just completely accepted his change of name with the continuation without questioning it at all. So
Paying Van Mill Farms LLC.
garnishment, so not part of any part of the garnishment period, but before they were paying Van Mill Farms LLC. Yeah, that's my understanding.
Different than Mashon Van Mills.
Yes, that is not the same as him, which goes into the next part, which is in the garnishment. As the judgment creditor, I can't control what the sheriff puts on the garnishment form. We tell the sheriff, obviously, we want to garnish for these judgment debtors. Every county is slightly different about how they do that, and every county is slightly different on how much input they allow the judgment creditor to have. It's a very frustrating issue, but also their form.
Point though, the judgment actually does say the judgment is entered against Mashon Michael Van Mill, and then sub 3, judgment is further entered against the collateral described above in rem, and that's referring to the Farms LLC, I believe.
Think so. Again, I don't have it in front of me, but the in rem portion of the judgment would have been on the homestead, and that would relate to the $175,000 issue because, yes, ultimately, Stephanie Van Mill was deemed to not be an appropriate signatory to some of the documents, and so no personal judgment was entered against her other than as that part. But I guess my recollection is
Judgment is against Van Mill Farms LLC.
in front of me, I believe I drafted it to include that everything is against Van Mill Farms LLC, and that should be in the section before the individual part against him.
The order from the court.
I know I drafted that, it was part of the stipulation, but at no point were the parties involved thinking that Van Mill Farms was not still owed. This is the first I've heard that there is any issue with that. I know that the entity isn't in business anymore, so it's kind of a no harm, no foul in a sense. But yes, if that was the case and if that was really not a judgment debtor.
The judgment debtor, and you're seeking to garnish against an entity that owes a debt to Van Mill Farms LLC, but you don't have a judgment against Van Mill Farms LLC. That seems a little bit problematic.
Yes, I would agree with that. And not, as it turns out, in this specific case because of the other facts that occurred, but yes, that would be something that would be an error on my side for sure.
Okay, thank you. The case of Greenbelt Bank versus Van Mill and others is hereby submitted. We'll have a brief pause here while the next parties get ready for the case of Lofgren versus Simpson. Looks like, are the parties ready? Your computer, I've had computer troubles today, and I don't want to start if you're not ready. Okay, thank you. All right, we're here today for Lofgren versus Simpson. And Mr. Galligan, you may begin.
Thank you, Your Honor. May it please the court, counsel. I'm Brian Galligan. I'm here representing the estate of Louden Lofgren in this medical malpractice action. It involves the certificate of merit issue, which I know the court is familiar with, and I want to take this opportunity to thank the court for the opportunity to come here and talk to you and answer questions about this issue. I don't think that's happened very much over the course of the last couple years since the Miller case was decided. And since then, as I think the court understands, there's been sort of an explosion in the district courts, and it's impacted a lot of meritorious medical malpractice cases late in the litigation process. There are still unresolved questions after Banwart I'd like to discuss with you. And this case involves two separate claims that were swept up in the district court decision. One is the traditional medical malpractice claim that involves issues of standard of care requiring expert testimony. There's also the claim of informed consent, which we argue is not appropriate for a certificate of merit given the court's adoption of the patient rule in those cases in 1987 with the Pauscher decision. I want to answer any questions the court has, obviously.
Of an expert in an implied consent case, then.
It is to establish medical facts, Your Honor. The jury has to determine materiality in those cases. So materiality is something that would be based on medical facts, like an expert coming in and saying, there is a 1 in 1,700 chance that this risk may occur. The expert's job is not to then say, that is material. That's for the jury to determine in those cases. And that's made clear in Pauscher and I think subsequent decisions that if an expert is involved, and the statute here involved says if expert testimony is necessary, that's not always the case in informed consent cases. If we look at the Anderson versus Kana case, the court ruled that a physician's experience can be material, and it's up to the jury to determine that. That didn't require an expert to say that or to provide data on that.
True of medical malpractice cases generally, that some require expert testimony and some don't, right?
But when we're
Which?
talking about the statute at issue here, 147, 140, the statute is centered around standard of care. The certificate requires the expert to say they're familiar with the standard of care and that the standard of care has been breached. Standard of care is a professional standard. The only way to get that is through an expert. If we were still subscribing to the professional rule pre-Pauscher, that's what the courts required, was an expert to come in and say, the standard of care required this physician to disclose these risks. And those weren't disclosed, therefore there's a breach. And in fact, they didn't have that kind of expert testimony in the case of Pauscher, and the court reversed saying, well, that was dismissed because they didn't have that testimony, and then the court reversed saying that wasn't necessary. You didn't need to have an expert come in and say, this is the professional standard here. So to read the 147, 142 include these informed consent cases when we're talking about standard of care is sort of shoehorning this in. And you'd have to read standard of care to essentially include the professional rule, which is no longer the law in the state of Iowa. I struggle to see how, in this case, you could satisfy the requirements of 147, 140 in an informed consent case when that's not the proof that's required here. If an expert is required, it has to go to the materiality question, but the duty is established by the law.
Question look like in this case where the issue is the fact that it was a resident doing the surgery?
Is very closely analogous to the Anderson versus Kana case, which is a 2018 case in which this court reaffirmed the patient rule. And that is that that's material information as a matter of law, which the court decided in the Anderson case, that a physician's experience is material to the patient making a decision.
So as I recall that case, and I dissented, but it's the law, the issue was that the Dr. Kana had never done that surgery before. So here the issue is that allegedly the doctor allowed the resident to do this surgery. And in both cases, the patient wasn't informed, and an informed patient would have said, no thanks. So your point is in neither case do you need an expert in order to present those particular informed consent claims. Is that what you're saying?
And
to do that, you don't need a certificate of merit on that issue.
Your Honor.
fact that it was a resident, or was it the identity of the physician performing the procedure, or both?
Both. The physician has the relationship with the patient here. And Maggie Lofgren, the mother, was never told that a resident would be actually doing a part of the procedure and wasn't informed of that until after the fact by an anonymous letter. That's information that I think a reasonable jury could determine that patients would want to know when submitting their child to a surgery. And it doesn't require an expert to do that, just like the court in Anderson determined that that's information that a jury ought to consider. Now, whether the jury ends up going there and saying that is material or not, that's for the jury, and the courts have made it clear that's the jury's decision. It's not an expert to do that, and it's just, there.
Type of informed consent that might be like the leaving a sponge in where you don't need an expert anyway, or is your position that all informed consent cases as a category don't need a certificate of merit?
Consent cases don't, because the question of standard of care is, it's the professional rule. Now, when we get 120 days later and there's a 66811 designation, there may be the need for expert testimony to provide the factual basis for a materiality finding in cases such as Pauscher, where it was.
Did you?
I believe it is, Your Honor. I think that a jury could find that.
I can't remember now. Was there an expert designation made at all with respect to informed consent? Okay, all right.
Motion was filed, which is a point I want to get to at some juncture here this afternoon relating to the question of waiver. But I think wrapping up the informed consent.
If we apply Banwart, what's left of your case on waiver?
Actually, I think that Banwart, this case has facts that are distinguishable from Banwart such that the court can find waiver here and the outcome in Banwart would remain the same. And the reason for that is we can't ignore the majority concurrence in the SK decision. And, the SK decision focused on engaging in the litigation process and the prejudice to parties and the costs involved in the case as the case moves forward. The court also spent considerable time in that decision talking about the fact that there's an intervening statute of limitations that came and went during this process. In this case, the timeline matters here. The certificate of merit was served on April 22nd, 2022. A year later, the statute of limitations expired. While the parties did discovery and everything, the parties disclosed experts, full experts, not just standard of care, which the certificate requires, but experts on causation and standard of care, as well as an expert on the consent issue, and a human factors expert.
Just come back to Justice Waterman's question on Banwart. I mean, I'm understand what you're talking about in terms of the SK concurrence, but in Banwart, we said there's a bright line rule on this waiver issue about the dispositive motion deadline, right? And bright line rule would, by definition, mean that it didn't matter whether or not there had been discovery or any of those other things that you just mentioned. So it seems like for you to prevail under your waiver theory, we have to abandon the holding in Banwart.
I would encourage the court to reconsider the bright line rule. And I think it would be appropriate here because the dispositive motion deadline doesn't accomplish what this statute sets out to do. At the point of the dispositive motion deadline, merit in all of these cases that have made it that far has been established through full expert disclosure, not just on standard of care, but also on causation. Significant money and resources have been spent by both sides. The healthcare system has incurred cost in defending these cases. The
legal significance of Dr. Meyer's supplemental affidavit?
Dr. Meyer did provide a curative affidavit establishing that, the concern here with the affidavit and the swearing is, is there conscience bound? And this curative affidavit establishes that. The courts have recognized that in oath situations such as this, a curative affidavit can relate back because the mission's accomplished. If he had, in fact, provided falsehoods in that affidavit, he could be prosecuted for perjury.
addressed the relation back doctrine yet, have we, in the certificate of merits?
You haven't, Your Honor.
A relation back and here be consistent or inconsistent with Banwart?
Banwart, I don't think addressed that question, and Banwart didn't have a curative affidavit. So I think this is an issue unique to this case, and I think there are other cases before the court that have that.
Miller at the beginning, and in Miller, we said 60 days means 60 days, right? And they tried to come forward and cure the situation later on, if I've got my case right. And Farman before that also. So efforts after 60 days to cure it seemed to me contrary to both of those cases, and also contrary to an elaborate statutory system where you can get an extension if you move before the 60 days runs, right? Or if you get an agreement.
The affidavit in Miller it made no effort to comply with the oath requirement, and I think it was a letter from an expert, whereas the certificate affidavit here was affirmed by the expert did certify their opinion, and the expert would be criminally responsible under issuing a false certificate.
Though, right? We've said that sort of affirm type language. It's just not adequate unless it's, and this goes back to Banwart, right? Unless it's an affidavit that's actually qualifies an affidavit or a penalty of perjury statement, and you didn't have either of those, right?
Banwart, it did not, and we would agree with the dissenters in that case that it was substantially compliant, and would love for the court to revisit that question, but here we are today.
About the discovery in the case. So the expert who signed the certificate of merit, was he deposed later?
He was deposed.
One certificate in this case? And he was deposed later, put under oath, sworn in. The defendants had all the opportunity to ask what they wanted to do. I guess my question is, does that have any relevance in this case? I mean, we've established a timing rule in Banwart, but it seems like if you have a certificate and then you actually put the expert under oath and take testimony, it seems like, to me at least, the purposes of the statute seem accomplished at that point. So I don't know if you've thought about that at all, but.
Because he's under oath and he's stating the same opinions. And I think it goes to the notion that of the transition of rules like the one in the Certificate of Merit statute, where they are mandatory, but they can transition to a directory function once the purpose of the statute is accomplished. And it's the Estate of Entler case that the court decided that discusses that notion. And it's really at the 668.11 point where the proof is put out. The purpose of this statute has been met now. Merit has been established. And so at that point, you have a merit not only on standard of care, but also causation under 668.11. I would advocate that the court could pull back the Banwart bright line to 668.11 deadline. Banwart didn't have 668.11 experts. So in a sense, it doesn't change the ultimate outcome, but at the 668.11 deadline, the plaintiff, the patient has put their experts and certified to the court all opinions out there. So merit's established at that point. The purpose of this certificate statute goes from mandatory to directory, and the defendant at that point, according to the Entler case, has to show some prejudice at that point. And I think that's, Entler is 398 Northwest 2nd, 848. It's a 1987 decision. Because I think this notion of these certificate or these oath statutes going from mandatory to directory, otherwise we allow ambush at that point. I mean, the meritorious cases all over the state of Iowa are being thrown out because of this, if I may finish, because of this. I mean, they're past that point where all the cards have been on the table, they're trial ready. And the purpose of the certificate of merit has gone away at that point, and costs are being spent.
Okay, you'll get a chance to come back. Thank you.
May it please the court, counsel. I'd like to pick up with the factual question about the expert's deposition in this case. My recollection is that the expert's deposition was taken after the motion was fully submitted to the court, but we didn't have a ruling yet. And so in an effort to keep the case on track in the event that the motion was denied, the expert's deposition was only taken at that point. With respect to the applicability of the Certificate of Merit statute to an informed consent claim, there was discussion during plaintiff's presentation about the Kana case, and it's important to keep in mind that that case did have expert testimony to establish that the risk at issue needed to be disclosed. At page 541, the court noted multiple experts opined that Kana's lack of experience and training on this Bentall procedure increased the odds of serious complications.
That was not, I mean, but then there was also a jury finding that he wasn't negligent. And so the jury finding kind of basically canceled out the expert testimony, but the majority said doesn't matter, the claim still properly should go to the jury.
But I think the point is that there was expert testimony from which the jury could find that.
I mean, as I read the majority, it's saying that expert testimony isn't needed because that testimony in effect says, there's increased complications, but yet you then had a jury that said Dr. Kana wasn't negligent, and nonetheless, even with that, we or the majority reversed the case and said the informed consent claim still should trial.
I agree with the dissent in that case. That was a question of causation, about whether the causation element in an informed consent claim requires that the undisclosed risk be the thing that causes the injury. It wasn't a question of whether there was sufficient evidence to prove liability, because my recollection is that informed consent claim didn't get to the jury, so the jury didn't even decide whether there was a material risk that wasn't disclosed.
I think of the dissenters was, you shouldn't, the whole reason why inexperience matters is because there's a risk of negligence, which is what those experts said. And the majority said that's irrelevant. It doesn't matter that there was a finding that there was it's a separate issue. If the patient was entitled to know about the lack of experience and the patient would have said, nope, I prefer not to do the surgery, that's enough. And so I don't understand for that specific claim why you need an expert.
Well, I think looking back to Pauscher, the duty of the physician is to disclose risks that a reasonable patient would find material. Whether a risk is material in general requires expert testimony on the nature of the risk and its likelihood of occurrence. That's the same issue here. With respect to a resident participating in the procedure, plaintiffs need expert testimony as to what are the risks of I believe, a fourth-year resident.
Common sense. Yeah, I mean, you tell me that I go to a hospital and I'm going to have my kid go under for tubes or whatever, and I don't find out till later that a secretary did it. I mean, to me, anybody who's not a doctor, it would scare me to death. I don't think you have to be an expert to know that.
Well, I think that hypothetical is quite different than a fourth-year resident who's about 6 months away from.
In the eyes of the public, I mean, that's common sense for us. You can't just have anybody be a doctor and perform surgery. I think we basically know you have to hit a high level of certification, qualifications, MD, DO, whatever you want to call it. We know that. I think you're underestimating the knowledge of jurors when it comes to who's a doc and who is not.
Your Honor, what about a situation where you have a doctor who's 90 years old as compared to a resident who has been trained on much more recent techniques?
I'm concerned about that one. But my eyeballs would not tell me that with a fourth-year resident who looks like a doc, walks like a doc. I wouldn't, but a 90-year-old, I think I could sniff him out.
If there is no statistically significant difference in outcomes for a fourth-year resident versus a first-year doctor, that's exactly why this court in Pauscher said expert testimony is generally required to prove these claims.
Expert testimony is about the materiality, right? It's not what the standard of care is.
care in any kind of negligence claims is the standard by which negligence is judged. It applies a duty to specific facts.
I think, from Pennsylvania, that makes a distinction between patient and professional standards. But in that case, Pennsylvania had actually recently codified kind of a combined standard. And so in Pollock, they made the point that it's because the defendant, even if they lost under the patient standard, they still had kind of this fallback defense that they could say, well, that's in accordance with accepted medical standards. And so that part, the professional standard was codified in part of that decision. What is your response to the Pollock decision with respect to that difference between the patient and the professional standard?
Your Honor, I think just more broadly, the court pointed out that, they looked at the big picture and said the scope of the rule cannot be limited to a technical reading to preclude its applicability to a cause of action that is based upon an alleged lack of medical information as would fail to attain informed consent to undergo a medical procedure. I think just we're looking at this statute as a whole to any extent that there's.
Shortell versus Kavanaugh case from Connecticut. Okay, it is similar to Pollock, except that it's more like Iowa in that it has a full patient standard rather than a professional standard. And so it held a certificate of merit is not required because there's no standard of care to develop. And it actually used kind of some reasoning from our Estate of Butterfield case. So if those cases are contrary to what you're suggesting, are you asking us to then be contrary to what other states, at least, that have looked at this distinction between a professional standard and a patient standard with respect to certificate of merits?
I would point to the Maryland certificate of merit statute that's cited in the brief. It's Maryland Code Section 3-2A-04B. And Maryland is also a patient rule state. Their certificate of merit requires a quote, or that the plaintiff must, quote, file a certificate of a qualified expert with the director attesting to departure from standards of care. But then they still found it necessary to explicitly exclude informed consent claims from the applicability of that statute. So I guess I can't speak to the reasoning of the Connecticut court or what arguments were presented. Here, I think the big picture is any informed consent cases are negligence cases. We know that. That's established in Pauscher and has been repeated time and time again. I mean, I guess I don't recall specifically, but I think it's pretty undisputed that the cases sound in negligence. How the court phrases the elements may change, but that's how the court lists the elements of negligence in a motor vehicle accident is different than how it lists them in a regular.
Anderson said you could have a doctor who did everything right and there's nothing wrong, and yet if the doctor failed to disclose that he had never done the procedure before, and the patient wouldn't have gone ahead if they had known that, then the patient is entitled to recover damages. That's the informed consent claim, even though there was a bad outcome, but the doctor did nothing wrong, and that's kind of Mr. Galligan's theory here, at least as far as that claim, right?
I think that's right. I mean, the resident was dismissed from the case because they didn't have any allegation of negligence against him. But I think looking at negligence broadly, a standard of care is just a standard of conduct by which negligence is judged. And then a breach or violation of that duty is a separate element. In order to determine how the general duty to disclose applies in a specific case, there has to be proof that a risk was material. So going back to your point about the Anderson case, the plaintiff still had to prove that the risk that wasn't disclosed was material. Whether the risk is material or not dictates the doctor's standard of conduct by which the doctor is judged. It applies the general duty to obtain informed consent to the specific facts of the case, and then as to the breach element, that expert testimony on materiality is necessary to determine whether the risk that was undisclosed was material.
Informed consent cases that would not require a certificate of merit in your view?
I think it's certainly possible, just like there are sort of ordinary medical negligence cases that can fall under those obvious exceptions.
The fact that a resident was to perform this surgery falls within which side of the line?
Requiring expert testimony, because again, similar to Anderson, they had expert testimony on, it wasn't just that the doctor hadn't done the procedure, it was that they had experts saying, if you haven't done this procedure before, there is a greater risk of a negative outcome. So that's the type of expert testimony that would be necessary here.
Is the legal significance, if any, of the supplemental affidavit? Can that relate back to cure a defective original certificate of merit?
Your Honor, for one, as this court found in both in Miller, where the expert later provided a sworn statement, in the Farman case, where they later tried to serve a certificate of merit.
Open question, because Farman was just interrogatory answer signed by the lawyers, so that there was no affidavit or certificate of merit that was defective that could be cured by a later curative affidavit. Same with Miller, was just a letter from the expert anesthesiologist. There wasn't even an attempt to put it in the form of a certificate of merit. So if you assume this is an open question, why shouldn't a subsequent affidavit relate back?
The Court of Appeals had kind of the first crack at the statute in McHugh and pointed out that the 60-day deadline is material to the statute's purposes. And so the compliance has to occur within that time. Years later, the expert's saying, oh, well, back then I actually thought I was under oath, even though the statute says affidavit 6 times and says it must be under the oath of the expert. All of that also falls within it must be done within 60 days. So
we treat affidavits generally. I mean, there's a whole law about what affidavits are, how they can be cured, et cetera. And I think the case law is pretty clear that something that purports to be an affidavit, and let's say it's missing a jurat, if the person was actually sworn and put under oath, that can be cured at a later hearing or by later affidavit. Similarly, if the person thinks that they were under oath, you can cure that by subsequent testimony. I mean, that's just kind of affidavit law generally, independent of the certificate of merit statute. So why wouldn't it apply here?
Two things, Your Honor. One, I think the statement in this case didn't say that, oh, someone actually put me under oath and they forgot to add the jurat. It just said, I thought I was under oath. That's not the same thing, because one is binding and actually subjects you to penalty of perjury, whereas the affiant's subjective belief about whether they're under oath, I don't think changes the analysis for purposes of criminal liability.
Do you agree that 622.1 also applies to the substantial compliance prong? So it's not just affidavit, it's 622.1 also?
I believe 622.1 goes to the under oath requirement. Separately, affidavits are also required to be under oath. I guess we don't really know the answer to that. I think in Miller, the court addressed them both together, both the oath and affidavit requirements. So I guess I'm not sure if you can disambiguate them for purposes of 622.1. But in either case, the certificate of merit in this case did not say it was signed subject to penalty of perjury. So whether it applies to the under oath requirement or the affidavit requirement, in either case, there was not substantial compliance.
Question about this. Setting aside the specifics of the case law on affidavits, is there any reason why that body of law wouldn't apply here?
60-day requirement in this case does change that analysis, because the point is that the defendant is supposed to be apprised of all of these things early in the case within that time. Again, this court has found not this court, the Court of Appeals, in a case that has been cited by this court, has found that that deadline is important, especially in light of,
I mean, the definition of relation back is that a court deems an act to have occurred at a prior point in time for all legal purposes, right? I mean, that is the purpose of the doctrine, is to make this later act legally occur here. So if that's the general rule and the way that rule works, why wouldn't it apply here when that's how it applies to all other deadlines?
let me respond to your question. I would point out that in some other circumstances, like with pleadings, there are explicit rules on when something relates back. I think given the context of 147, 140 as a whole, the fact that it explicitly only allows an extension if requested before the deadline expires, if the legislature intended for a subsequent act to relate back, it would have said so. And in fact, given that we have other expert disclosures that come down under 668.11 and 1.500 sub 2, then it would almost erase, it would drastically undermine the purpose and undercut the usefulness of the statute and the effect of the statute. So I think the legislature had the opportunity to, like the rule on amendments, put in an express provision, and it didn't.
Actual matter, I guess I'd like you to explain why that's true. So you get a certificate of merit. The case is litigated for 2 years, I think in this case, right, with discovery, et cetera. We have some cases, it's 4 years. And now suddenly you're saying, after doing all the discovery, finding out the case has merit, you've taken all the depositions, that the purpose of the statute, which is to quickly get rid of cases, is somehow undermined because the expert files a curative affidavit after the case is ready to go to trial. I don't understand how that, if you thought the affidavit was bad, it seems like the defendant should have moved to dismiss it very early in the case, but that didn't happen. So under these facts, how does that undermine the statute?
One, as the court noted in Banwart, the statute is for the benefit of the defendant. The defendant has the ability to control the timing of its motion subject to the court's dispositive motions deadline. There's obviously numerous tactical considerations that go into when to file motions. But beyond the specific facts of this case, I think the statute has to have bite both as a general matter. There's specific deterrence and general deterrence, and if the statute is constantly being put aside, it's not going to serve its purpose of requiring proof of merit and also early investigation and identification of experts. And so, again, the statute needs to be enforced as it was written, and I think.
You're talking about the 60-day period. You had the substance of the certificate of merit. It was just a fact of whether or not it was properly under oath, right? So it's not like the 60-day period, you missed the substance of what they were, the certificate of merit was going to say. That you got that in that first 60 days, right?
Yes, but it being under oath is clearly the legislature thought that was important.
Agree with you there, but with respect to this argument about relation back and the importance of the 60-day period, if you've gotten what was kind of the guts of the certificate of merit within the proper 60-day period, I'm not sure why the relation back, it's so horrible that the relation back doctrine would allow that part of it to be fixed later.
Well, one, it would create a brother's keeper situation where we file a motion and spend the time and effort to draft a motion, and then the plaintiff's counsel says, well, my guy thought he was, I don't think any expert is going to say, no, I didn't think I was under oath, I didn't think I complied with the statute. So it essentially writes that affidavit and oath requirement out of the statute. And again, I think the legislature spoke to this when it said, if you have a problem and you can't get this done in time, you have to ask before the time runs out. And that's not what happened here.
If the court were considering a relation back doctrine to be applied in this case to ask for supplemental briefing, we've got a lot of brain power in both sides of the V, defense and plaintiffs' lawyers. I don't think we've specifically asked for supplemental briefing on this issue. What's your take on that?
Inclined to make a ruling based on that issue, then yes, the defense would appreciate the opportunity to familiarize itself with the cases that the court has referred to and respond specifically to that issue.
True lawyer, it depends.
Thank you, Your Honors.
Mr. Galligan.
Thank you, Your Honor. May it please the court. Counsel. I want to address the 60-day deadline. The statute isn't just about 60 days. It's about 60 days, before 60 days and before the commencement of discovery. And those words have been sort of ignored in all the discussions about this particular statute. They have meaning. There's a discovery moratorium until the affidavit is presented, and the defendants can refuse discovery. Plaintiffs need discovery in these cases. They have the burden of proof. The commencement of discovery matters. The defendants in this case received the certificate of merit in this case, which said, I affirm and state and certified the opinions of Dr. Meyer, and moved forward with discovery without challenge for 2 years. And I think it's significant also, counsel referred to the Banwert statement that, well, the brother's keeper and defendants control that. But you know, in the SK decision, there is a quote from, and the court quoted the Lalonde case, which said, though defendants are not expected to bend over backwards to save plaintiff's claims, allowing limitations to expire before asserting a right that significantly pre-existed the time bar provides some indication they intended to waive the pleading defect and the remedy. Again, this case is different from Banwert. There was a year that elapsed. A significant amount of litigation occurred before the statute of limitations expired. I think that there was a reason for that language in the SK decision, because that is important. There is a significant amount of prejudice to.
Until after there's a jury verdict appeal, I mean, it was very different. Then in Banwert, we tried to provide clarity with a bright line rule. Could you address why, if we're going to have a bright line rule so we don't have to litigate over and over again, how much discovery was too much? Why should we move it up from the dispositive motion deadline, which is about dispositive motions and the deadline, move it up to 66811, which is a reporting deadline? And then I would think there'd be time to react to see what the report said and make a strategic decision. So why should we disregard stare decisis and change what we said in Banwert to move it up earlier?
In time, it would be good for the court to align the deadline with the purposes of the certificate of merit statute. When we have the dispositive motions deadline as the date, let's say we're in a district without court reporters and the case gets continued and continued again and continued again. That deadline keeps moving out. 66811 is a hard deadline at 180 days. It is also referenced in the statute, 147-140, and says, you know, you still have to comply with this. Why would the legislature say you still have to comply with the statute they never repealed unless they intended to incorporate it and have it work in tandem? It makes sense, right? You file your certificate of merit to demonstrate that this defendant belongs in the case. They're not just there to scattershot the case and see who belongs and who doesn't before experts. So that allows discovery to proceed. But once we get to 66811, all the cards are on the table. The lawyer is certifying to the court under 66811 that these experts are going to testify to standard of care and what their opinions are, causation and what their opinions are. Merit is established at that point. And after that, if we're allowing challenges to this and without a showing of prejudice, once it becomes directory, then we're getting rid of meritorious cases, and Iowa citizens are being denied their chance to have their cases heard by a jury that are meritorious.
The court should request supplemental briefing, including amicus briefing, on the issue of whether a curative affidavit filed in response to a motion to dismiss should relate back to the original certificate of merit.
Decision is always the best decision, Your Honor, and I think because of the magnitude of impact of this certificate of merit issue and the number of cases this court is facing, either that are percolating up or not, I would welcome the opportunity. I wanted to point out to the court, defendants provided additional authority in the last week. And the Estate of Speaker case was one of those cases that the Court of Appeals decided. Judge Sandy in that case wrote a dissent, and he did provide a path for the court to find estoppel here and distinguished it from waiver, which was found in Bamward. I would call the court's attention to that. It's an important doctrine that I think is still alive and has not been addressed. And again, it goes to the point of we're litigating these cases beyond the purpose of the statute. And Justice Sandy's dissent was right on with the New Jersey case of Knorr, which the court found no waiver, but they did find estoppel. And I think it's an important precedent that the court ought to look at in considering these issues. Thank you.
Thank you. The case of Lofgren versus Simpson and others is hereby submitted, and court is adjourned for the day.